And we are live streaming through the digital airwaves of LinkedIn, Twitter, YouTube, Instagram, Facebook. This is Coffee with a Lawyer. I'm Justin Sterling, a personal injury and business lawyer. This is your chance to ask the lawyer your legal questions for free. This is why I do what I do, to help people deal with their legal issues, improve their lives, and make a meaningful difference. Please know there is no attorney-client relationship. There is no confidentiality. What we say here could be discoverable if you are in any legal matter. This is only meant to be general information and not specific legal advice, and I encourage you to keep your questions general. If you need to speak about specific details, it's best to schedule a confidential consultation with a lawyer. And today we have a special guest, and I'd like to allow you the opportunity to ask any questions you may have or any discussion topic, and I'm happy to be of service. Go ahead, sir. Are you with us?
I'm here.
Yes. And I know you, I'm familiar with your situation a little bit regarding arbitration provisions, employment law disputes. We did discuss a little bit already. Just want to reinforce what we talked about arbitration provisions, that they are alternative dispute resolutions. They take you out of court. They basically deprive you of justice, of your day in court. Now, there may be some times when they are preferred for cost-effective reasons, but generally speaking, we want to be in court. Those are the doors of justice. We want your day in court. This is your right to a trial, a decision amongst your peers, a jury trial. Do you have any other questions that we'd like to discuss?
I do. Real quick, the biggest thing on my mind that I'm hoping you can answer is, in the event where you said there's negotiations made and say we're bound by that arbitration contract and we're not allowed to proceed to have our day in court, if that were the case.
Mm-hmm. It depends.
Will it matter how you said this is a completely different kind of court? It's not court at all.
Right.
My question is this: all the evidence, even witnesses and text messages, we can easily prove, this is why I want to be in front of the judge, that they're lying and they're blatantly making up a lie. Their whole facade is completely false and it's easy to prove wrong. Will that matter in this kind of court? Because in criminal court, it will. In a jury, it will. But they are Pinocchios.
I understand. Yes, you'll have an opportunity to present evidence in the arbitration.
Oh, cool.
It depends. Now, again, you have to review the language of your contract. It is all controlled by the contract language. You have to review what type of proceeding it is, arbitration, binding or non-binding. Is it appealable? It is all addressed in your contract. So you have to review that. You have to give that very critical scrutiny and understand what type of process you're in. It seems like you're past that process already. I don't know if you have reached a decision as to who the arbitrator is. That is also another point of negotiation with the opposing side, who is actually going to serve as the arbitrator. And you want to do some investigation. Who are they? What are their credentials? How many arbitrations have they done? Are they favorable to big corporations or to the employees? You have to do some investigation, and then you guys have to agree who will serve as the arbitrator. Now, in your contract language, you may have already designated what companies may serve as the arbitration provider. For example, there's ADR services, there's JAMS, there's different procedures that you can follow, such as the AAA procedures. That's what does it stand for? The Association of Arbitration. Let me see.
It's called AA. I'm writing these down.
Sometimes the American Arbitration Association, and they issue standard procedures and rules on how to conduct arbitrations. Do the rules of evidence completely apply? It's all based on contract. because basically you guys have agreed to resolve a dispute outside of the court process. You have given up your right to file a lawsuit. And I know, yes, it's disappointing, because as a plaintiff, as a citizen in our society, that's your that's your constitutional right to seek recourse, justice in our court systems. That's why they're there. That's where we resolve our disputes in civil society. But however, based on your employment contract, your contract language, you have foregone your right to pursue a lawsuit in court through this arbitration provision. They're difficult to overcome. A lot of times as plaintiffs' attorneys, we look for ways to defeat them, to make sure they're not enforceable, for the most part, by arguing that they're unconscionable because they were hidden in contract language. They were in small print. You had to, I mean, they gave you a take it or leave it. They said you can't have this job. Yes.
It doesn't tell you sign here to be a victim, later on when we do what we do to everyone. Yeah. You don't know what you're getting into all the time.
Yes, you have to be very careful when you're signing agreements. You have to understand what you're signing. I mean, at a more basic level, for instance, when you sign up for a gym, you're signing releases and waivers that you're not going to sue the gym if you're getting hurt there. It's very difficult to sue a gym for an injury that you suffered while exercising, because you sign so many waivers. You have to read the contract language. Now, is it negotiable? I mean, everything is negotiable, but will they hire you if you don't agree to their terms? Most likely not. They may not say that's the sole reason, because but you have to be informed, and perhaps you can negotiate more favorable terms. But hindsight is always 100%. We are where we are at, and you're proceeding to arbitration. I would first have a discussion with your attorney to determine if it's binding arbitration. Most likely it is, because it seems like they were in a more powerful bargaining position, and they're probably more informed with their legal team, and they have very well drafted contract language. So it's probably binding arbitration, which means that you won't have another shot at it after this.
But this is what I wrote down. Just add if you want. It's regarding arbitration, scrutinize non-binding or binding. Who is arbitrating? Who are they? Who are they mainly for? And then I wrote down American Arbitration Association, and any other things I can write down to share with my lawyer about that.
Well, find out if it's going to be a panel of arbitrators or if it's just going to be one arbitrator, and what their background is. Are they a retired judge? Are they a practicing attorney? How many years did they practice? On what side did they practice? Were they a defense attorney? Were they a plaintiff's attorney?
What side? How many years? My lawyer will be able to tell me all this, right?
Oh, absolutely. And from the sound of it, from what you've discussed with me, it sounds like you have a very competent attorney.
I agree. I know she definitely knows what she's doing. I had a choice, actually, of a huge firm that always deals with this. Very huge, meaning like you get a phone call from a different person every week, and they're not really always caught up, and it took lots of time for anything to trickle or any phone call to get returned. I picked a private, smaller business that maybe hasn't done it. She's done it a long time, but I don't think, she's kind of new, I think, as far as being a leader at that firm, but knows exactly. I just feel like it was more personal and smaller was probably going to be stronger. And just by our talks, it was more understandable. It was a really hard choice. I remember that, because they were both licensed lawyers. So at the end of the day, it was really hard to make that call. Me and my wife discussed it. And in order to pick, everyone was just saying it didn't matter which one it was. They're both going to be able to do the same thing. I even touched in with you about it. So we just went with the smaller one that seemed to return calls and be more in connection, a closer connection.
Yes. Well, many times that is the benefit of going with a more smaller local firm as compared to a larger, big law, national billboard firm, because on those larger firms, you will not get the personal attention that you may need for your specific case. And you may just be considered another statistic in a big law firm, and they may not be able to gather the information and the evidence that is particular to your case in order to properly advocate for you and maximize your recovery, because they're not involved so much in your case. You're being handled by case managers, by assistants,
Yes,
paralegals, and the attorney is not evaluating the file, the facts, the evidence in order to zealously advocate for you to maximize your case. A more personalized, localized firm will be more involved. The attorney will be more involved. They will be there with you side by side. That's why I've always preferred to keep my practice limited, because as an attorney, we're fiduciaries. We're in a position of trust. And I just don't feel good about treating a client's life like a business matter. This is personal. This is we as an attorney, and look, employment law is not my niche practice. I'm more in the civil, the litigation, negligence law, injury matters, and business disputes. Employment law is a different ballgame. They are quite extensive. They're longer cases. They're more document heavy cases because you have to go back and evaluate all the correspondence, all the internal emails that were done. All right. I'm sure there was a lot of discovery done in your case, and it's very document heavy. You have to evaluate a lot of paper. All right.
Yeah.
There's a lot of because disputes are all about relationships. And in an employment relationship, you guys are very close. Sometimes in your employment relationship, you're more closer than a marriage. It's more intimate. There's so many communications and interactions that were performed amongst the parties that you have to really conduct discovery into. You have to find out what went wrong in this relationship. But I digress a little bit. I just want to make clear that as an attorney, when we take on a case, we're in that realm where it happens really once in a lifetime. You know, this business dispute, we hope you don't get into multiple employment cases in your lifetime, but a lot of times it's just once in a life, and people don't know how to really handle these situations. So we have to be there for our clients because it's it's a personal, intimate, and it's a scary situation.
Absolutely. Yep. And I already knew that with you. I didn't know how huge you were, but I could feel it from the gate. You helping people for free on Mondays is already a cut above. But you're right. Exactly how I felt was throwing down a pipeline of business. And I'll be honest with you, man, not to put feelings into it, but we felt like the other huge firm, the television commercial, big, huge firms in the huge area we won't mention, but you feel less care. You feel less cared for, not just because you're not even speaking to the actual lawyer, but if you can't speak to your actual lawyer and they can't guide you, through the process effectively, they can't what I liked about my lawyer, she didn't sugarcoat much. I didn't like a lot of the stuff she said, and I still picked her because that's a reality. And she speaks like you, where they can only do what they can do with whatever's facts there is or whatever contract you're bound to. So we like that she was real and that she's willing to fight and just present as much as possible and do what we can do. It doesn't mean I'm okay with it. It just means we're going to go as far as we can possibly go, because no matter what, we're not going to get a quarter of what's. And I just know this. I'm setting myself up in my head from just you're confirming that we might not get our day in court. There might not be real justice here. So the more I can stomach that, it'll help. Because we're not going to get half of what's owed, and I already know that for a fact. I've looked up all kinds of these cases and outcomes of these kind of cases and what exactly has happened from point of view myself and the effects that it's caused and everything that's attached to it after the fact. Whether they disagree or not, we know exactly what's happened and how they did and how they've done a lot of people, not just me. And, it not sitting well in my spirit and me being usually the most patient, understanding, and I was hired to fix the problems that only got worse. Like I was happy about this at first. So ours is really complex, but me knowing it's not going to be half of what our outcomes should be, it's never going to sit well in my spirit. It's never going to be right. And from what my lawyer's telling me, it really bugs me, but they're not going to be affected. It's not even going to be a slap on their wrist. And that's what bugs me the most. And that's why whoever's listening, if there's anyone more grateful than a lawyer, I'd like to meet him. But for people like you, if there's anybody that's alive, more grateful to have lawyers and someone to be in our corner to defend us as much as they can fight legally. I didn't know how to fight legally until a few years back. I got sober about 8 years ago from alcohol and started to really change my life and get custody of my kids and
God bless
and do all that. And I grew up at a Christian school. We didn't stay on, the straight and narrow all the time. But I'm in my 40s now, and it took a long time. I was the latest bloomer in the world, but it's better to learn late than never. And I look on the bright side where if I'm learning this stuff right now at 43, then I'm glad. I'm trying to focus on what I can get out of it, not just financially, but it was devastating. And it's been way too long a process. And it's just been twisting the knife the entire time. And like I said, knowing our outcome isn't going to be half of what, I'm looking up, which I probably shouldn't. I just need to know all the facts because that's how I am. I can't figure nothing out. I can't start another company or career without knowing about these agreements that I'm signing and not reading all the small print and figuring out what went on wrong and how not to harm not just me, but my 2 little girls, my little boy, my wife. They've harmed all of them, but for something I signed, and just the realization of swallowing that pill, and it's an accident, but there's nothing we could do at this point other than what we're doing. But to just carry on and move forward is always the hardest thing after getting jumped and beat up, this big money corporation. I'm not getting into like how many men. I've told you, I got picked over 1,000 applicants, at least months and months and months and years of applicants, and the job availability always open online and stacks of applications. And I know this full well when I was tight with both lead managers who brought me on and then canned me for opening my mouth. I got brought on because I kept my mouth shut.
Well, sir. All right. Well, let me just remind you that of the non-confidentiality in these webinars. So we don't want to get it too much into specific details, but you bring up some really great points, and your perspective is it's enlightening and it's inspiring, and I'm sure many other people feel the same way. And let me just elaborate on what you said, because these situations go beyond just you. They affect your whole life and the people around you, your loved ones. And what you said about the slap on the wrist is absolutely correct. And that's why these large corporations with bargaining power enforce these arbitration provisions, because the purpose of the arbitration provision is to keep you out of court so that these large corporations can avoid what we call nuclear verdicts by a jury trial, by a trial amongst your peers. They want to avoid the multiple and multiple tens and multiple millions of dollar verdicts that could really put a large corporation out of business. They want to avoid that by depriving you of your right to seek injustice in the courts, in which the possibility of obtaining what we call nuclear verdicts is very real with zealous advocacy. And then again, it goes back to the attorney and what the points that you made as compared to a personalized attorney who zealously advocates for you, or a big law attorney at a large law firm, because each case falls on its own facts. It has to be cultivated. You have to work closely with your attorney. You have to trust your attorney. It is a teamwork situation. One, because you know your facts the best. The attorney does not. All right. You lived it. And as an attorney, we can only rely on you to provide us the facts so that we can spot the issues and then analyze how to apply the law to your own particular facts. The argument has to be customized to your case. We have to work together to zealously advocate for you and provide the legal arguments so that you can maximize your recovery, your recourse, your justice in this particular situation. A large firm that may only provide your case facts and your file to a paralegal, a case manager, or a subordinate is not going to be able to do that because they don't have the proper training, the proper personal attention to zealously advocate for you and to analyze your particular facts. And they may only apply a general cookie cutter argument. And that doesn't really help you. All right. So there is a balance. Large firms may have the resources, all right, to finance your case, but a localized solo or a small firm can give you the more personal attention to be in the case with you, to be with you along this journey, because it is a long process as you're experiencing. Justice is certainly doesn't happen overnight. It's a process, the discovery process, the depositions, the interrogatories. It is a fact-finding process. It's a search for the truth, and it doesn't happen immediately. It is a long, dragged out process sometimes. So having an attorney that wears multiple hats, one as a legal advocate and a lot of times as a personal advisor, it can be helpful. But you have to balance it for each case. Each case is different. You have to be able to evaluate it. It's a trust. You have to interview your attorneys to understand that you feel comfortable with them. So there's a lot of different dynamics that go into play, but your perspective was very insightful. And as an attorney, I need to hear it from the public. I need to hear it from clients, what they are looking for in an attorney, because it helps me improve my practice. It's a practice. It's something I have to do regularly. Like you said, it's life. You know, you talked about your sobriety, and I commend you on that. That's amazing. It's never too late. It's never too late. And I'm sure your life has changed for the positive. So I commend you. I too have cut out alcohol. It's made all the difference. All right.
Right.
You take away those personal defects of character, and your life can be amazing beyond your wildest dreams. It's amazing, and I can get to be of service. But I have to hear it from others. So I'm have an immense gratitude for you for sharing this
Likewise
with me.
Justin, I forgot one quick thing, man.
Yes.
I totally have to get this answered. Is 40% a lot of any outcome that we have? She'll be getting 40%.
In employment law matters. Okay, so we're talking about contingency fees. And contingency fees, attorneys are bound by rules of ethics, all right? Their fees cannot be unconscionable, all right? They must be reasonable. And again, you have to read your attorney-client agreement. Make sure that she made you understand that it is negotiable. 40% in an employment law matter is reasonable, because employment law matters can be complex. But in order to determine the reasonableness of an attorney's fee, you have to consider the complexity of the case, the length that it's taking, There's many different factors. It's not set in stone, like, anything above a third is, unreasonable. But even still, it's always even negotiable, even after you settle the case.
Okay, it didn't sound negotiable at all. She was very adamant on what it's going to be and didn't mention that. So that's good.
Well, so it's also negotiable on her side. Maybe she's not willing to take less than that because she knows the difficulties in employment law cases.
Doing a lot as well.
Yeah. Well, it's again, everything's a balance.
Stuff for that.
Yeah.
I mean, my whole family has suffered so much, and whatever outcomes are looking, plausible, that's too much as far as, we're gonna be freaking like if I told you the facts, you would understand. It's because I can't, but it's very, very low, and it's just like, what the frick did I even do any of that for?
I understand. I mean, a lot of things go into play. I mean, like, how long have you been out of work? Have you been able to find alternative employment? Have you mitigated damages? Have you, a lot of things go into play. I will say this in terms of the fee with the attorney. Even after you settle the case, you may want to have that conversation with your attorney. Now, it is all controlled by the contract, but you can always adjust the fee. All right. I want my clients to, happy clients is what we work for. So I try to work things out with my client to come up with what is fair and reasonable considering the circumstances. And
right. Who's prefer you? We are.
Yeah.
That's it.
And also when you go to arbitration, this could be a way where you guys can resolve it that is reasonable for you, to adjust fees, play around with numbers so where it all works out. Okay. You will want to take a look at your attorney's costs. All right. Determine if they're reasonable costs. You may want to look at the receipts for the costs she's charging you, because they could be inflated. That's a way that perhaps the fees can be adjusted. You want to review everything. I know the way I handle my practice is I have very intimate conversations with my clients to determine how we can work this out in order to resolve a dispute. There is that fine line. There is that number where it all just works out. All right. So you just got to be able to find it. It's all negotiation. All right.
Thank you, man. I'm grateful for you.
Well, I'm here every Monday, 9 a.m. And I know, employment matters aren't really my niche, but this is still a source that you can tap into. And people watching online, streaming, please feel free to type any questions in the chat. I'll try my best to get to it. I'm here every Monday morning. We do try to stream regularly, and it's just a place where you can stay accountable. And it's great for other people who may already be involved in a legal matter or trying to handle it on their own, or may already be involved with a lawyer. This is just a great place to get some more insight, to feel more at ease, and to make progress, to stay accountable. That's the key here. It may not be resolved immediately, but at least you can keep tapping into so you make progress. So ultimately you can achieve your objective and win your case. And I'm here to be of service. A great way to say thank you. And I know a lot of times I may not always have the answer, but I will do my best to get you in the right direction or get you to the person who can. A great way to say thank you is to leave a positive review on my Google profile or Yelp profile, and I can leave a link in the chat. You're not required to. I understand, it's no obligation, but I will be truly honored and grateful if you were to leave a positive review. I really appreciate kind, positive reviews. That's really what makes my job rewarding. I love to hear back from people that I help and stay involved with. It's, I just have extreme gratitude for people who leave reviews. I think it's amazing. So every Monday, we're here. Let me put the review link in the chat. And you don't have to go too into detail with any review. Just, just say that you spoke to me. If you can spread the word about our free webinar here, that's great, even because the more people that we can help, the same way that I help people here, is my purpose. It's my mission. It's why I do what I do. It's why I became an attorney, because it allowed me to be of service to others. And I can help people along this journey, this experience that we are involved in, your legal matter or life in general. So I will put a link in the review. Okay. And I will also leave my email. Feel free to message me anything. Email is probably the best way. I will also leave my cell number in the chat. You can always text me. I'm very text friendly, my mobile number. And yeah, I put this out there on the chat. I'm available. Message me. I'll get back to you. You'd be surprised. I put this out there, but not too many people actually take advantage of it. You see here on Monday, we're here free every Monday. But I commend you for signing on because it shows you care. And I'm certain things will work out, one step at a time.
Awesome. That's great to hear. I just want to say two things that were going in my head as you were talking. The knowledge is so powerful. And this quote I can't get out, we never freaking lose, we win or we learn, is all I'm like, just trying to magnify these positives. And I'll definitely leave you an awesome review. I was hoping to be done with the case before I did, but I guess I don't need to be, since it's a free open webinar session. That way others can know what you provide and how to tap in. Because I guarantee, and it's your practice, so there's thousands of people who just need to speak and talk with you, and your guys' hours are not cheap. Any licensed lawyer. So we thank you, and it's very commendable, and good job on the sobriety as well.
Thank you,
we'll talk to you again.
Thank you. Take care. Take action. More will be revealed. Bye for now.
All right. Bye.